and by conduct, cultural identity, and for this contested case hearing, a Native Hawaiian cultural practitioner. All petitioners here, including those who claim to be Hawaiian...
Clarence, can you stop 1 second? The folks that are outside the door, could we have you quiet down a little bit? The court reporter is having a hard time listening to the testimony.
Do we need to talk louder?
No, Clarence, they...
Go ahead. I didn't hear
another minute.
Hawaiian subject, racial by U.S. definition, Native Hawaiian, and implied conduct cultural.
Yeah, all petitioners here, including those who claim to be Hawaiian cultural practitioners, were held to be admitted as parties, having qualified for standing by Minute Order Number 6, order regarding standing on May 27, 2011. Furthermore, according to his findings of facts, it seems that the hearings officer used some kind of qualified standing, regular standing, plus an additional standing qualification in regards to constitutionally protected Native Hawaiian cultural practice. The HO failed to provide prior notice of his intentions and failed to include such standards for qualification in Minute Order Number 1, the Notice of Standing and Pre-Hearing Conference dated April 10, 2011, or anywhere else. Such error cannot be tolerated in retrospect. There is no discussion anywhere in the record of HO's finding of facts, conclusions of law, or decision that outlines the specific standards that he would use to evaluate a cultural practitioner's qualifications under the umbrella of constitutionally protected, constitutionally guaranteed protections. The HO further erred by modifying the standards of proof for civil cases by using Hanapi's criminal standards for qualification. To be held to standards that don't exist or noticed must in the least be a violation of petitioner's due process. Additionally, petitioners Mauna Kea, Anaina, and Clarence Ching were petitioners in the contested case hearing on the Conservation District use application for the construction and operation of 6 1.8-meter outrigger telescopes. In that contested case hearing, whether or not these petitioners were qualified as Native Hawaiian cultural practitioners was at issue. The HO in that CCH, after hearing, found and concluded that these petitioners were qualified for standing with constitutionally guaranteed protections as Native Hawaiian cultural practitioners. This board confirmed that these petitioners qualified for standing, and so did the Third Circuit Court that heard the appeal. Based on the qualification of said petitioners in that CCH and appeal, it is res judicata, and the HO is stopped to re-challenge said petitioners for standing in this CCH. It is especially absurd when the finding and conclusion here is 180 degrees out of kilter, a denial of such protection. The law does not favor such inconsistency and uncertainty, and the HO erred. Mary Pukui in Nana Ikikumu, Look to the Source, Volume 1, page 94, says that in Hawaii's early days, one's name was one of one's most precious possessions, and one's Inoa name was both owned property and a kind of force in its own right. Once spoken, an Inoa took on an existence invisible, intangible, a kapu, tabu, becoming attached to the name. An example of this phenomenon in real time occurred when applicant's witness, Wallace Ishibashi, in his cross-examination, 9/17/11, transcript on page 105, was on the stand. He was asked a question about his family's aumakua relative to Mauna Kea. His response was, well, we take it as, again, every family has their own secret in how they do their thing. But yeah, on Poliahu, which we recognize as the location of where we have an aumakua. But I reserve the right to keep that in the family. As for me, in addition to my hesitancy in reading the actual names of my familial relations, that could meet the Hanapi Prong 2 test reveals at its very foundations a deep-rooted conflict between the course of the so-called state of Hawaii and long-standing practice and conduct of Hawaiian culture. There must be a simpler way to qualify Native Hawaiian cultural practitioners in legal settings than to unreasonably discriminate against their cultural philosophies and conduct. and that is that they don't talk about their genealogies. To refuse to remedy the situation by insisting on the use of Hanapi Prong 2, among other things, may constitute a violation of due process and civil rights of Native Hawaiian cultural practitioners on Mauna Kea. The Native Hawaiian cultural practitioners here, in addition to verbal and written statements they have made or referred to, have in addition, upon oath, stated that they, as individuals, are Native Hawaiian cultural practitioners. How redundant must BLNR and the HO be then, in the face of a cultural and or familiar kapu, to not reveal such personal and sensitive information, to insist on requiring additional specific information. To insist on more specific genealogical information would be to improperly discriminate against Hawaiians as cultural practitioners. Do Christians have to swear their genealogies upon oath in order to practice their religion? This illogical conclusion, among other things, seems to be a violation of the Equal Protection Clause of Constitutions. Let me state in the record for yet another time that I qualify as the Hanapi Prong 2 standard. This is one of my genealogical lines. Interestingly, some of the names on here that I choose not to reveal on this record are names that are also on Chairman Aila's genealogy. This really turns out to be one of the more grave issues in this CCH. And I would exhort you to pay serious attention to its resolution, as it will be referred to later in this presentation. After all, the question should really be whether petitioners are Native Hawaiian cultural practitioners, and not necessarily who their specific ancestors are or when they lived. It should be sufficient to simply state under oath that one is a qualified Native Hawaiian cultural practitioner. Facetiously, should the state start issuing licenses to those who may qualify as Native Hawaiian cultural practitioners? I don't think so. For the HO and BLNR to insist on such a rigid and arid requirement as Hanapi Prong 2 and try to coerce Native Hawaiian cultural practitioners here into violating their family kapu with such requirements is preposterous. But getting back to the CDUA. Because TMT Observatory Corporation is the party that requires a permit to build the gigantic 18-story telescope, one would expect it to also be the party to submit the CDUA to BLNR, right? Wrong. The applicant is UH Hilo. So the CDUA does not contain a single signature of any authorized TMT person. As an additional point of interest, while one would expect the TMT Corp to be the party opposing the petitioners in the contested case hearing, as you already know, again, it is not TMT Corp, but UH Hilo. Of course, with UH Hilo as the applicant, one would then naturally assume that a legal relationship exists between it and TMT Observatory Corporation, right? Wrong again. There is no operating agreement between the two. So how can UH Hilo legally submit an application for a third-party performer that it has no legal relationship with, such party being responsible for completing the proposed project? In a sane, logical, and legal world, the existence of such an agreement would be fundamental, expected, and required, if only to delineate the rights and obligations of the parties involved. The involvement of UH Hilo in the application process seems to be as a volunteer, facilitator, or initiator, with no legal relationship with the party that's supposed to perform all the obligations that would be included with the granting of a permit, if indeed one is finalized. Additionally, UH Hilo, as an entity of the University of Hawaii, holder of the general lease for Mauna Kea, may have a conflict of interest in all of these dealings. Excuse me. Furthermore, that the actual party in interest, the hopefully responsible party that will raise the funds, submit the designs, comply with all the laws, rules, and regulations, and build the building and its instrumental contents, is a corporation without a corporate history, corporate success, corporate assets, etc., should raise an entire battery of questions. What is the TMT Observatory's corporation's corporate credibility and creditability? Not one single iota of this necessary information is in evidence, and no one of consequence, including BLNR, is asking questions about them. So while there is privity, a legal relationship between BLNR and UH-Hilo because of the CDUA, there is no privity between UH-Hilo and TMT. Therefore, there is no legal relationship between BLNR and TMT. And except for the granting of a CDUP with its conditions, no conduit through its legal communications and relations can take place. It continues to be interesting that so far the legal and other expenses for the TMT are over $1 million and rising. Of course, the beneficiary of whatever benefits should accrue, TMT, is picking up the tab, right? Wrong again. It's the University of Hawaii and you, the taxpayer, who are footing the bill. Furthermore, one would expect that TMT Corp, the performer, would be responsible to produce a necessary environmental impact statement. Well, not so. It was UH-Hilo's attorneys who hired the firm during the EIS, and I suppose that whomever does the hiring also pays for the service. But remember, there's no operating agreement. So how could there be an arrangement? I'm afraid that, again, the taxpayer is footing the bill. Credit must be given to the TMT Corp personnel who creatively engineered this business plan to get these multi-million-dollar benefits and not have to pay for them. There doesn't seem to be any provision for a subsequent payback either, as there is no agreement that specifies the situation. Heck, further examination reveals that TMT doesn't even have a sublease upon which it could build a telescope that UH-Hilo is applying for it to build. And as a consequence of this situation, the rent that BLNR should be evaluating for adequacy and compliance is nowhere in sight. Will the amount of rent, when it eventually appears, satisfy the recommendations of BLNR relative to the CDUA that states that TMT remains committed to paying a substantial amount for sublease rent? More so, we also need to be reminded that the individual shareholders, members, or whatever the constituents of this TMT corporation are, normally by law, not liable for the liabilities of the corporation. In other words, not even the sovereign nation states involved are liable for payment. Benefits with no liabilities. Who said there is no free lunch? Well, it is common, if not a necessary practice, that corporations without a history of successes and inadequate credit rating usually require personal guarantees in its commercial transactions to guarantee full performance for its undertakings in case of unexpected contingencies. None has been provided for or required in this situation. Is this reasonable and prudent on BLNR's part? With little or no practical experience, defective decision-making becomes a real possibility. How does BLNR protect the so-called state and its beneficiaries from such contingencies? So whether it is the applicant, in this case UH-Hilo, or the builder-operator, TMT Observatory Corporation, BLNR should require that one or both of them provide guarantee surety of such proportion to secure and or ensure that, once started, this project will go to full completion. 20% of the fees collected by the Mauna Kea Land Special Fund, HRS 304A 2170, are being set aside for payment to the Office of Hawaiian Affairs. Precedent has been set. It is suggested that this arrangement be further documented in any CDUP that may be granted. While existing telescopes provide viewing time to UH in lieu of rent, no proportion of equivalent value have ever been shared with the Office of Hawaiian Affairs for its 20% share of all rental proceeds, as far as I know. The proposed CDUP, among other things, does not mention viewing time in any of its discussions. Not only should the subject of viewing time be included in the CDUP, but that 20% of the equivalent value for viewing time to be shared with OHA should be mandated. Curiously, TMT will color the pavement of the access way, the roadway to the observatory, to blend with the surroundings, yet it insists, and the HO has gone along with the suggestion, that the coating of the dome will be a reflective aluminum-like coating which will reflect the sky during the day, reducing visibility. To claim that a reflective aluminum-like coating reflects the blue colors of the sky seems to be a figment of somebody's PR myth, surely not reality. In my observation, other aluminized domes presently on Mauna Kea have always reflected the glare of the sun, but never a blue sky. If the roadway and supporting buildings are colored to blend with the surroundings, then I would suggest, even require, to maintain consistency of argument that the dome be colored likewise. After all, my view of an eventual TMT observatory, if it should be built, will be from Waimea, and the dome, colored like its surroundings, will be more tolerable if blended rather than glaring. Relative to spatial relationships in Mauna Kea, the university moves its different physical orientations either from being close to the other observatories of the summit area or at a great distance from them, depending on the advantages or disadvantages of the issue it is addressing. For example, regarding Section 13.530C5 Hawaii Administrative Rules that states, the proposed land use shall be compatible with the locality and surrounding areas appropriate to the physical conditions and capabilities of the specific parcel or parcels. It is so understandable that the university would take a close-in perspective for this one, that the proposed TMT observatory would be compatible with the locality and surrounding areas of the other observatories, although the actual proposed TMT observatory location is over a quarter-mile away, except for the sub-millimeter array from the nearest other observatory. A quick glance at a map clearly shows how remote the proposed TMT observatory is from the cluster of summit observatories. On the other hand, it is undisputed, paragraph 91 of HO's conclusions of law, that cumulative effects of astronomical development and other uses in the summit area of Mauna Kea have previously resulted in significant and adverse impacts. The trick here is to locate the TMT observatory as far away from the summit area as possible so as to argue that TMT observatory impacts will be minimally cumulative to the significant adverse impacts undisputedly having already tainted the summit area. Either of observatories, or it isn't. It cannot be close for some arguments and far for others. After all, one of the laws of physics is that a thing cannot be in two different places at the same time. Pu'upoliahu is the major physical feature on the west side of the Mauna Kea summit area. I can attest to the height of the Pu because it is a challenging hike to the top of its summit. While the sheer size of the proposed TMT for a man-made object, being approximately 1/3 of Pu'upoliahu's height, is monstrous. Moreover, how can the addition of the proposed TMT observatory with spatial dimensions, width, length, and height, practically dwarfing the total of other observatories on Mauna Kea, already declared to constitute significant and adverse impacts, not cumulatively add additional significant and adverse impacts, and not violate the threshold of being significant and adverse, as the HO suggests? While such mental hocus pocus, along with alchemy and witchcraft, might have attained credibility in the Dark Ages, my modern mind tells me that one cannot subtract or mitigate by adding. The summit area of Mauna Kea is substantially developed. That it occurs in the conservation zone is as mythical as the existence of unicorns. The conservation zone in the summit area has been totally decharacterized by observatories. It is so totally developed that there is no room on it to build a gargantuan facility such as the 30-meter telescope. The character of the summit of Mauna Kea would not be further developed, even if the heart of Waikiki were to be transported to the mountain. But such development is not allowed in a conservation district and therefore is not allowed atop Mauna Kea. That there are no guidelines in existence regarding development limits on the mountain is a travesty. It was a major oversight to not have been included in the comprehensive management plan. Moreover, that the negative impact on the mountain is characterized by the number of telescopes on the mountain and not by their sizes and heights. The actual impact of their existence seems to be a fallacy. After all, 10 TMT-sized observatories would have a mega impact on the mountain when compared to 10 12-inch sized telescopes. In each case, there being 10 of them. But the actual impact of a telescope is, I would guess, more proportional to the cube of its primary lens radius than by its unitized number. To shift gears a bit, let me suggest that the CDUP process does not comply with the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP. Although President Obama and the United States had initially opposed signing the declaration, on December 16, 2010, at his second Tribal Nations Conference, he, the President, reversed his earlier decision and stated that he would sign. And indeed, a query to the White House about how the declaration would be implemented was referred to the State Department. Spokeswoman Tiffany Miller responded by email that there is no simple answer. As you know, the declaration has implications for many agencies across the U.S. government, she said. However, I can tell you that the Obama administration is committed to making U.S. support of the declaration meaningful. Citing Article 32 of UNDRIP, I conclude that this CDUA process is non-compliant with the article. Article 32, 2. 1. Indigenous people have the right to determine and develop priorities and strategies for the development or use of their lands or territories and other resources. 2. States shall consult and cooperate in good faith with the indigenous peoples concerned through their own representative institutions in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. 3. States shall provide effective mechanisms for just and fair redress for any such activities, and appropriate measures shall be taken to mitigate adverse environmental, economic, social, cultural, or spiritual impact. While I have no knowledge if UNDRIP has been an issue of any appeal in the so-called state of Hawaii yet, I suggest that this board start thinking about the day that it will. In fact, I'll even suggest that the board start paying attention starting with this contested case hearing. The day of reckoning is here. Amy K. Lear, in an article entitled Looking Ahead, Indigenous Peoples and Free, Prior, and Informed Consent stated, the UNDRIP sets forth the responsibility of governments to gain free, prior, and informed consent from indigenous peoples for development projects. It has already been cited in national court cases, particularly in Latin America, as support for the requirement that governments seek free, prior, informed consent from indigenous peoples and cease giving concessions to companies until consent is obtained. Thus, although the UNDRIP addresses governments, it will directly impact companies and the university in this case. UNDRIP, coupled with the Hawaiian Kingdom's Instrument of Accession that was filed with the United Nations Secretary General on December 10, 2012 in New York City, that invokes the jurisdiction of the International Criminal Court over Hawaiian territory beginning on March 4, 2013, gives notice that a new paradigm is taking place in Hawaii. The ICC prosecutes individuals and not states for war crimes committed within occupied territories. Only states can accede to the jurisdiction of the ICC, and that Hawaii achieved the international recognition of its statehood on November 28, 1843, by joint proclamation of Great Britain and France, and entered into extensive diplomatic relations and treaties with other states. The justification for the accession was based on 2 points. First, the acting occupying government is not able to enforce and prosecute individuals for violating Hawaiian law. and the law of occupation taking place within Hawaiian territory. And second, the U.S. Pacific Command, the occupier, has refused to hold to account individuals for committing war crimes that have been reported since July 6, 2012. According to the United Nations War Crimes Commission, war crimes include usurpation of sovereignty during occupation, denationalizing the inhabitants of occupied territory, confiscation of property, wanton devastation and destruction of religious, charitable, educational, and historical buildings and monuments, etc. So please take notice that these developments may eventually apply to you. In conclusion, I exhort you to examine petitioners' arguments on the merits and deny the CDOP. And while you're at it, you should reverse the HO's erred findings, conclusions, and decision that the Native Hawaiian petitioners here are denied standing for constitutional protections of all rights customarily and traditionally exercised for subsistence, cultural, and religious purposes, and possessed of ahupua'a tenants who are descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. I think this list goes back further than 1778, since there are about 90 generations on here. I thank you.
Thank you, Clarence. So I'm going to ask the question that I've asked almost everyone else. Should the decision stand and it go forward, will you stop going to Mauna Kea?
I think that's a very good question. But the answer, I believe, cannot just be a yes or no. However, I will go as far as to say I will not stop going to the mountain. However, as Pua Case said earlier, every time she goes to the mountain from now on, already and continuing, that there are compromises, spiritual, mental, these kinds of things that we have to make in order to go up there. I mean, after all, these observatories are not invisible, they're there. And you almost have to sort of condition yourself to ignore them. But let me tell you, it's very hard to ignore.
Thank you. Next up is, excuse me, next up is Mauna Kea Ainaho, Kealoha. Got it? Aloha.
Aloha. Aloha. My name's Kealoha Pisciotta. I'm here on behalf of Mauna Kea and Ainaho, myself and my family, my kupuna. Just for the record, I'm going to read from my notes. In October, I had a stroke, so I don't need real accommodation, I don't think, but recovering every day, and mahalo ke akua. But just so you know, I have a hard time a little bit with words and things, so.
Take your time then.
So I just want to say a small pule for opening, because I will be speaking of the sacred things, and then I will end it at the end, if that's okay. Aloha kia kua na kua nama kua. We ask you abide with us this day as we speak on the sacred issues. Grant us permission to speak to the sacredness of Mauna Kea. We ask blessings for all, and those who have traveled far, may they be returned home safely, back to their loved ones, and we ask for forgiveness of any trespass that may occur. Aloha kia kua na kua nama kua. I will free that prayer when I'm done. Mauna Kea is sacred because in our cosmology, or our worldview, Mauna Kea is an origins place. For us, it is here where the heavens and the earth come together and where all life forms originate from. It is a temple, but not one made by man, but rather made for man, so that man could learn the ways of the heavens and the laws of the earth. And man could learn how do we live in relationship with the earth, and how do we live in relationships to the heavens and to each other. According to our Mo'olelo or oral history, the god Kane was chosen by the Akua before him and made him the one who brought down the baskets of knowledge so that mankind could live rightly. In the Kumulipo, the chant of creation, we learn before man was born, mostly all other living things were born before him, thus teaching us our place in the world. The Po, the infinite potential, the great cause of all life, is where we came from. We came later, and all those before us came from there also. And they become our older siblings. And when they are under attack, we defend them. And we ask that the unraveling of creation not begin. Because after all the science we have on Mauna Kea, we don't have any science that teaches us how to bring our species back from extinction. And that is not permitted. That is not our human right to have. So this is what Mauna Kea represents. It represents our zenith and our ties to creation itself. And it is this basis that gives it its power, and also that it is the sentinel of the Pacific. There is no other like Mauna Kea. So when we ascend to do ceremony, we ascend back through the genealogy of creation to the point at which the Po and the light were given birth to. So before I get into the substance of the issues involved, I have to digress a moment to address the university's latest allegation, and that is that it goes something like, they know that we're Hawaiian, but we never proved it. And therefore have no constitutional protections for our cultural and religious practices that we execute on Mauna Kea, or our native Hawaiian rights, in other words. You know, I've tried to think of ways to explain the fallacy of this argument without sounding terse, but I can't. So this allegation is simply ridiculous and preposterous. I cannot believe that the university, which is considered our center of higher learning, would take this position, and I don't even know how to respond, but I have to. So these are some of my reasons why that is a fallacious argument and should be struck. First, the university misconstrues the law, attempting to apply a criminal standard to this case. That is where Native Hawaiians use their constitutional Hawaiian rights to launch an affirmative defense against criminal trespass charges. But we are not criminals, and this case is not a criminal case, but a civil case involving Native Hawaiian traditional and customary practitioners who are attempting to continue to practice their constitutionally protected rights on public, ceded, and undeveloped lands, which is exactly what Pash case was all about, and exactly what the court was seeking to protect against in that Pash case. Further, because many of us, and that is at least Mr. Nevis, Mr. Ching, Ms. Ward, and I have been previously found to have standing not only by this board, but by both a state case and a federal case, more than one state case actually. And so the university is consequently barred from challenging us at this point. You know, the courts can't make flip-flop decisions, so that's our position. So we have 6 other reasons in our briefs, and I won't go into those right here, but I would encourage you to review at least our Native Hawaiian rights section for that area in our brief. So returning to the issues at hand before us today, why we're here before this board. The short answer is we're here today because BLNR said yes when they should have said no. The job of any regulatory agency, including BLNR, is to regulate, and that means sometimes it needs to say no to projects like the 30-meter telescope that are inconsistent with the purpose and mandate that govern the Mauna Kea Conservation District. But we have been coming and asking the same thing for a long, long time, years now, coming to BLNR to ask that they do their job, which is to conserve our natural resources, such as our lands, the animals, to protect the Native Hawaiian and the public's rights. We began in the 90s trying to have input in the UH new development plans, which plan to exceed the legal limits of 13 telescopes allowed on Mauna Kea. The plan agreed upon by not only the university, but BLNR. And if my, sorry, and if my memory serves me correctly, when we first began coming before the BLNR, it was 6 chairpersons ago. We had Mike Wilson, Gil Kaloma Agaran, Peter Young, Timothy Johns, Laura Thielen, and there was another one, and I can't remember his name. Oh, Alan Smith, and then now you, Mr. Chairman. To find justice, we have had to come before the BLNR in contested case hearings to compel them to follow the rules, the statutes, and the Constitution that are already written. We're not asking for anything new. And that failing, we went to the courts. We went to a federal court, we went to the Third Circuit Court, we went to the Intermediate Court of Appeals. Now, all of the state courts found in our favor. I think it's safe to say that we have fulfilled our civic duty. And as Judge Hara affirmed, our rights have been prejudiced because we have had to go beyond our normal duty as regular citizens and engage in these contested case hearings and the court cases. So I'd just like to point that out. We've had to go and endure all of this because BLNR has acted in a political rather than as a trustee, which is proposed in the Admissions Act and in contradiction of the law. BLNR is empowered to conserve and care for the land, and they are specifically not mandated to be proponents of development, such as the TMT Corporation, and that's why we're here today. The state recognizes the conservation districts of Mauna Kea's importance as well, because they have created laws specifically protecting Mauna Kea. And under state law, it is considered, under state law, public lands are held in trust for only 2 beneficiaries, Native Hawaiians and the general public. The state is but a trustee, not the owner. The public and the Native Hawaiians are the owners. The state holds and has and continues to have an affirmative duty to protect it on behalf of the right holders, the owners who are the Native Hawaiians and the general public. This is affirmed in the Admissions Act. In short, BLNR is mandated primarily to conserve our lands and natural resources, period. So we're here because the Constitution affirms that Native Hawaiians have a right to continue their traditional and customary practice on public lands, and because the public has a right to a clean and healthful environment, and BLNR is required to protect that on their behalf. But this is not what's happening. What's happening is that BLNR has not chosen to protect those rights that they're mandated to protect, but they're there to protect the rights instead of the residents of Pasadena, California. The residents, more specifically, of the corporate members of Pasadena, the rights of citizens of other countries like Japan, France, the United Kingdom, instead of those who the laws were there to protect. We know foreign citizens have no rights here, or at least land rights. So the real question that needs to be answered is, what law is BLNR relying on to give non-taxpayers, non-citizens, not only the right to use our land, but the right of destruction of our land? And what laws are you relying on to give foreigners the right to pay only $1 a year in lease rent? That's the question. What we do know is that BLNR has a non-transferable duty, and that means that they cannot be given away to the university or anyone else to protect the public's rights and the reasonable exercise of traditional and customary Hawaiian religious rights. That also means they cannot let private entities like the TMT Corporation or the university, a subdivision of the state that is not mandated to oversee the conservation district like the university, to perform these duties. BLNR has an affirmative duty to protect the people, as the Supreme Court has repeatedly upheld. We believe the evidence in this case demonstrates that the TMT project is inconsistent with the laws and the policies of the state. And to understand, we need briefly to trace the origins of BLNR's responsibility to the people of Hawaii, and that is the identity why BLNR has, exactly why the BLNR has a fiduciary duty. It begins with the Admissions Act, the state of Hawaii's constitution, and all related statutes and rules and regulations governing the conservation lands of Mauna Kea. So let us review. The Admissions Act is a federal act, a compact or agreement made between the United States Congress and the people of Hawaii, thus forming what is known as the state of Hawaii. And regardless of the tenuous history that led up to the statehood, the Admissions Act clearly identifies certain agreements made by America, and they take precedent, and they shall establish once, oh sorry, did I miss something? Hold on one second, let me go back. Yeah, identifies certain, agreements made between America and the people of Hawaii, and they take precedent as they establish some of the fiduciary obligations that BLNR as a state agency has to the people of Hawaii, and at a minimum, the state must follow its own laws. The Admissions Act established the lands of Hawaii are to be held in trust for the purpose of the betterment of the condition of Native Hawaiians and the general public. The state shall be the trustee, it says. In other words, the lands of Hawaii must be used in a manner consistent with the Admissions Act, and again, a federal law. I would like to take note that the racial identification for Native Hawaiians came into existence in 1920 and 21 when Congress made the 50% blood quantum requirement for Hawaiian homelands. However, the Admissions Act provides for the Hawaiians of less than 50% and other actual subjects of the kingdom of all ethnicities. Hawaiian is a political identification, not a racial one. Now, the Mauna Kea Conservation District lands are entirely comprised of those public trust lands that are identified by the Admissions Act. However, these lands have protection not only under the public trust laws, but under the conservation and historic preservation laws of the state of Hawaii as well. Therefore, in considering the TMT district use permit, BLNR must consider how those proposed projects like the TMT benefit the people of Hawaii, better the condition of Native Hawaiians and the general public, not the interests of international astronomy industry or foreign direct investment to be subsidized on public lands by the taxpayers. The state constitution contains in Article, I think it's 12, Section 7, affords the protection of Native Hawaiians' traditional and customary rights, while Article, I think it's 11, Section 9, provides that all the people have a right to conservation and a clean and healthful environment. So when the question arises, should a new telescope project be approved by the BLNR, we must consider their obligation. But did BLNR consider it? Well, when the TMT proposal came before BLNR, the DLNR staff affirmed, and I state, from a cumulative perspective, the impact of past and present actions on cultural, archaeological, and historical resources is substantial, significant, and adverse. These impacts would continue to be substantial, significant, and adverse with the consideration of the TMT project and other reasonable foreseeable future projects. Further, the former DLNR chair, Ms. Laura Thielen, states, and I quote, "It is our view that the effects of astronomy development on cultural resources and on the landscape of Mauna Kea has been significant and adverse. While a project such as the TMT can bring new resources into play that might mitigate certain